Today, we are going to talk about the Second Amendment right to bear arms, and we're going to go into detail about exactly what the United States Constitution says in relation to the Second Amendment. Hello, everyone. Thank you for joining my show today. I'm Joe Pometto, Joe the lawyer, a practicing attorney here in Pittsburgh, Pennsylvania. I want to tackle this topic for a couple of reasons. First of all, it's a major issue. It always comes up in politics, especially in the last 10 years, but even shorter than that, with mass shootings across the country, gun violence, etc. It seems as though the left really wants to push forward and regulate guns, and the right is really standing hard and fast, don't want their gun rights infringed upon. So it's a major issue. The reason I want to tackle it is more so because of reason number two, and that is there is a ton of confusion around this issue. The left may think, oh, we can do gun buybacks, and there's leftist politicians out there saying we're going to come and we're going to take your guns from your home, da 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 da. Well, can they do that? On the right, you have people saying, you can't touch my weapons, you can't do this, you can't take gun buybacks, you're going to have to pry them from my dead hands. Well, is that true? Are they right? Second Amendment advocates always say that pretty much any type of gun control is a violation of their Second Amendment rights. Well, I'm here to tell you that that is not necessarily true. Number three, with everything that's going on down in Virginia, there's some laws being passed by the state legislature that are going to do things, I don't know all the details of the law, like gun buybacks. They're going to regulate the sale of certain automatic weapons, etc. So there will likely be constitutional challenges to those laws. Will those constitutional challenges knock down the laws, or will the laws hold muster? I'm going to go into today a case from 2008. It's United States Supreme Court case, District of Columbia versus Heller. This case and the law that came from it basically lays out the framework for the Second Amendment. Again, people go around and say, my Second Amendment rights are being infringed upon. You can't take my guns. Well, any person can come forward and say, this is my Second Amendment right, or this is my First Amendment right. In both of those areas, the First and the Second Amendment, there's often a lot of confusion, okay? And ultimately, what rights you have are determined by 9 individuals, the United States Supreme Court. And the lines aren't always black and white, but if you read the case law together, you can understand the legal framework for the First Amendment and the Second Amendment. So we're going to go into District of Columbia versus Heller today, and we're going to get a better understanding of exactly what the constitutional law says in regards to the Second Amendment. And on that point, it's important to remember that the Supreme Court, their interpretation of the Constitution is what matters as far as applicable federal law, and that can change over time. We've seen that in many areas. There used to be laws, federal laws banning gay marriage, and the Supreme Court took a different stance on the Constitution and struck down those laws. Whether people like it or not, the Constitution interpretation of it does evolve, because the interpretation always ends up coming down to the 9 people sitting on the court at the time that the decision is made. So I want you to keep that in mind while I read this opinion. Anybody could pick up the Second Amendment and say, these are my rights, da 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 da. I could read it one way, you could read another way, you could read another way. 3 of us sit around, all have a conversation, and we disagree. The only way that it matters as far as law is what the Supreme Court says. So we're going to get into DC versus Heller today. It's a landmark case. I'm going to add some of my comments to it. You can see this is a longer video than usual, so I hope you stick around. We're really going to learn something today, and the foundation of this video will be used for future videos when I cover gun laws and gun legislation. Before we get into the meat of the topic today, please like, subscribe, comment, and share this channel. Really what I'm looking for are subscriptions. Subscribe to my channel. Hit the notification button. If you don't like all the videos that come up, you can just ignore them or maybe unsubscribe later on. But when I get to 1,000 subscribers, I have over 400 right now, then YouTube unlocks certain features for me that I can use to make my channel better. And yes, it also allows me to get ad revenue at 1,000 subscribers. But let me tell you, my channel is so small, I'm not going to be getting significant ad revenue at 1,000. I'd rather have it unlock the cool features that help me make better videos. Also, sign up for my email list. It's in the description below. Click in the description. It's right at the top. There's a link. Click on that link. You can sign up for my email list. You get a free PDF on what to do when stopped by the police. If you're familiar with my other channel, I always have a beverage while I'm doing my videos. My other channel, Common Sense Academy, we do the same time sip. If you have a drink, raise it in the air. Cheers with me. It tastes better when we sip together. Okay. So let's start with the text of the amendment. The Second Amendment provides a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Until recently, the amendment had never been recognized by the Supreme Court as giving private citizens the right to keep firearms. But in a bless you. I'm not going to edit that out. Keeps it real. But in a stunning 2008 case decided by a 5-4 vote, District of Columbia v. Heller, the court struck down D.C.'s strict gun control laws on Second Amendment grounds. The majority of the court asserted that the inherent right of self-defense has been central to the Second Amendment right and concluded that the amendment confers on private individuals a right to keep basic firearms, including handguns, at home for self-defense. The significance of Heller, okay? The only significant prior Supreme Court decision on the meaning of the Second Amendment was in 1939 and had been widely interpreted as saying the Second Amendment gave no rights to private individuals and merely protected the right of well-regulated militias. And that the court at the time said well-regulated militias were now the National Guards. We'll get into that more. To keep their members armed while on duty. But Heller, the new case, 2008, concluded that this was not the correct reading of the 1939 case and that the amendment confers on private citizens, not just militias, the right to keep at least some kinds of weapons for self-defense and recreational purposes. I have to say, friends and viewers, I was surprised to read that, the private individual, the right of the private individual to have guns at home for self-defense was not protected until a 2008 case. There was so much going on in politics in 2008. I don't think this case got the attention maybe that it deserved. If it happened more recently, I think there would have been more of a media spotlight on it. It sort of slid under the radar. It's really, truly a landmark case in the Second Amendment fight. But 2008, we just had the market crash. Obama was running for president. Wars in Iraq and Afghanistan were at their height. So the political environment was very different when this decision came down. But you can see a Supreme Court decision has impact for decades, even longer sometimes. So the D.C. gun control statute at issue in Heller was among two or three of the strictest statutes in the United States. The statute contained two distinct prohibitions that were being challenged. First, the statute effectively banned the possession of handguns in the home. Only registered firearms could be kept, and handguns could not be registered. Second, the state required that firearms other than handguns e.g., for example, rifles, shotguns, could only be kept in the home if they were unloaded and either disassembled or disabled by a trigger lock. Let me stop right there. I grew up in Pennsylvania, okay? I didn't hunt, but my stepdad hunted, all my friends, my friends' parents, etc., etc. I mean, everybody in Pennsylvania has a loaded or has a loaded rifle in their house. Okay, so challenged by the plaintiff. The plaintiff, Dick Heller, was a police officer who wanted to keep a handgun in his house. He asserted that each of the above two prohibitions violated the Second Amendment right to bear arms. Talk about the perfect plaintiff. Those of you who don't know, when you're challenging a law, especially constitutional law, you need somebody who actually was harmed by the statute, okay? You need actual harm from the law, somebody whose rights were actually being violated in order to bring a real case before the Supreme Court. And attorneys, law firms, activists will find somebody who fits that description perfectly. A police officer is perfect because they're trained in weapons, okay? So this is just a great example. And police officers all over the country, they a lot of them have private carry. They probably don't do open carry, but they do private carry, concealed carry, and they likely have firearms in their home. So perfect example. By a 5-4 vote, the Supreme Court agreed that both provisions of the D.C. statute violated plaintiffs' Second Amendment rights. The majority opinion was by Justice Scalia and is maybe his most important opinion since he joined the court in 1986. When this was written, and I'm reading from an Emanuel law outline here, okay? When this was written, Mr. Justice Scalia was still alive. He's since passed away. 4 members of the majority were those generally considered the conservative bloc of the court. In addition to Scalia, they included Chief Justice Roberts and Justices Thomas and Alito. The critical 5th vote was supplied by Justice Kennedy. Justice Kennedy was a swing vote his entire career. He was central in the Obergefell decision, which legalized gay marriage. So I really like Justice Kennedy. I really like Justice Scalia too. I'm going to drop in a little personal story here. When I was in law school, I met Justice Scalia. They had a private meeting with him of all the law students who were presidents of some of the associations. At the time, I was the president of the International Law Association. I didn't do that much, but I did on that board, but I did more than the prior people did. I had a couple of different seminars, etc. Regardless, I met Justice Scalia, and I have to say he was a very great speaker. He was very blunt and right to the point. And I actually have a photo of me sitting next to Scalia, and our knees sort of rubbed together. Just saying, a little bit of that legal magic rubbed off on me here. I also, my last name's Pometto. I'm mostly Italian. I like that Justice Scalia was an Italian American who sat on the court. So Scalia's opinion in Heller began by considering the history and language of the Second Amendment. He separately analyzed the prefatory clause, which is the opening clause of the amendment, which states a well-regulated militia being necessary to the security of a free state, and the operative clause, the right of the people to keep and bear arms shall not be infringed. The operative clause is obviously the one that is operational, the one that actually sort of bestows the right upon the people. I must say, if you read this opinion, it's sort of like a master class in constitutional interpretation. Before you go to law school, lawyers, you take the LSAT exam and you take the bar exam later on, but most legal analysis or legal work, you play logic games. There's logic games on the LSAT exam, logic games, logical reasoning, and reading comprehension. Because really on the law, we read the law, we read the cases, and you're literally breaking down the meaning of every word, and its positioning in the sentence, okay, can have an effect on what its meaning is. That's why they say logic. If you take logic, you get into this, the course logic in undergrad. I took logic. I suggest it for anyone thinking of law school, but it's a good class to take anyway because you'll become a better thinker. So, the operative clause. As to the meaning of the operative clause, Scalia pointed to several elements that he said demonstrated the clause was intended to give rights to individuals, not just members of state militias. First, the operative clause codified a right of the people. In the use of this phrase by other constitutional provisions, such as in the First Amendment, demonstrated that the phrase customarily referred to individual rights, not collective ones, he said. Second, historical and linguistic analysis showed that the phrase keep and bear arms was unambiguously used to refer to the carrying of weapons outside of an organized militia. In summary, he said the text and history of the operative clause conferred an individual right to keep and bear arms. So you can see highlighted in this opinion, and you've probably heard this in the news, the battle between whether the Second Amendment was just for militias to have arms or just for individuals and militias to have arms. Justice Scalia, as you've already seen here, but you're going to see more, is he's saying it protects the right of militias and the rights of individuals. The prefatory clause. Next, Scalia analyzed the prefatory clause, the reference to a well-regulated militia being necessary to the security of a free state. As to this meaning, Scalia rejected the dissent's reading of this term as being limited to officially organized state militias. Little more constitutional learning here. In this case, 5 justices agreed with Scalia and struck down these laws that were passed in D.C. 4 justices did not. They voted the other way to uphold the laws. The 5 who struck it down are called the majority, and their opinion is the one that becomes law. Anytime you have a majority of opinion, you're likely going to have a dissent. A dissent is the opinion written by the 4 justices who voted on the losing side. Now, that opinion doesn't hold the force of law, but it can often, it has a lot of meaning because it comes from the Supreme Court, and sometimes it can help shape future decisions and outline the law generally. For Scalia, the term militia referred to all males physically capable of acting in concert for the common defense, and the adjective well-regulated implied merely the imposition of proper discipline and training. The reference to security of a free state referred merely to a free country or free polity, not to states as the operators of state militias. So the prefatory clause was not inconsistent with Scalia's individual rights interpretation, he argued. And this went to him attacking the prior decision which said the Second Amendment only protected the rights of the National Guard to bear arms, right? He's saying that this reference to militias is not just for the National Guards, which were less organized early in American history, became more organized later. The Second Amendment was in reference to any individuals who could come together and possibly form a militia in order to guarantee the freedom of the country. Scalia then analyzed the historical purpose of the amendment. The history behind it, he said, was that English tyrants had eliminated the ability of the militia, which are able-bodied men who could muster at any time, to resist tyranny not by banning the militia, by simply taking away the people's arms, enabling a standing army supporting the tyrant to suppress political opponents. Consequently, Scalia asserted the threat of the new federal government would destroy the citizens' militia by taking away their arms. That was the reason that right was codified in a written constitution. So what he's saying is that the English kings or tyrants would come in and would just take all of your weapons, and that's how they enforced their tyranny upon the people. And the Second Amendment was created to prevent that. That is what he cites as its historical purpose. In sum, the history leading to the enactment of the amendment and the common 18th century meaning of the phrases in it convinced Scalia that the framers intended to grant individual citizens the right to bear arms for self-defense, not merely to confer such a right upon official state militias. And that's something Scalia was really a genius at, was going back to the meaning of words when they were written. He's an originalist. This is part of what originalism means. It means interpreting the Constitution in line with its meaning at the time that he was written. Remember, I talked about the living Constitution. Scalia's not into that. Now, every judge engages in it to some degree because the world is always changing over history. But originalists are going to try as best they can to find the original meaning of the words, and going back, finding definitions for 18th century words and what they meant back there is important to them, because words we use today, we use the same words that they used in the 1700s, but their meanings have evolved. Scalia then argued that post-enactment interpretations of the Second Amendment had reached the same conclusion, that the amendment conferred an individual right to bear arms for self-defense. Scalia paid special attention to U.S. v. Miller, the 1939 case, which involved criminal charges of transporting an unregistered short-barreled shotgun. The court rejected the defendant's argument that their conduct was protected by the Second Amendment. The dissent in Heller contended that in Miller, the court held that only military use of guns were protected by the amendment, but Scalia disagreed about what Miller said. So what he's doing here, and what the dissenters on the court did, is they're arguing about what the true meaning of that old 1939 case was. Scalia is more or less reinterpreting it to fit his needs here, or the desired conclusion that he wants, but this is what judges do, okay? He may have read that case and had a different opinion of it from the beginning. Scalia said Miller said only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barreled shotguns. So for Scalia, Miller was not inconsistent with the Heller majority's conclusion that the amendment protects the rights of law-abiding citizens to possess guns for self-defense. Having concluded that the amendment protects at least some right on the part of non-military individuals to bear arms, Scalia now turned to the scope of the right. On this score, he indicated merely that the right was not absolute or unlimited. The majority was not, he said, casting doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. So by drawing this distinction, Justice Scalia left open a lot of room for the regulation of firearms. And what he says about Miller is that basically, that's fine. In Miller, they said the short-barreled shotgun was unacceptable. So there's still certain types of weapons that will be unacceptable, or I don't want to say unacceptable, types of weapons that can be regulated, okay? But what Scalia is really getting across in this opinion here is that handguns are not that type of weapon. Dangerous and unusual weapons. Furthermore, Scalia said the amendment protects only the carrying of weapons that were in common use at the time. The amendment was enacted so that dangerous and unusual weapons, quoting an 18th century commentator, would not be protected. In an ambiguous sentence, Scalia seemed to be saying that what he called weapons that are most useful in military service, M16 rifles and such, may be banned because they were not in common use at the time the amendment was enacted. This is a little weird here, but it's very in line with his originalist thinking, going back to the original meaning of the law itself. Scalia then applied his reading of the Second Amendment to the D.C. statute before the court. The ban on handguns. As to the absolute handgun ban, Scalia asserted the inherent right of self-defense has been central to the Second Amendment right. He said D.C.'s complete ban on handgun possession in homes amounts to prohibition of an entire class of arms that is overwhelmingly chosen by American society for that lawful purpose. Since handguns were the favored method of self-defense in the home, a complete ban on them violated the amendment. but Scalia did not specify what precise standard should be used, reserving that issue for future cases. The choice of standard was unnecessary to make here, he said, because the handgun ban was unconstitutional under any of the standards of scrutiny that we have applied in enumerated constitutional rights. Now, the type of standard used when reviewing a law is very important for constitutional interpretation. There is a rational basis, which is a low standard, an intermediate standard, and then strict scrutiny. Under the rational basis, most cases are upheld. Intermediate, it makes some cases are upheld, some are struck down. Strict, they're always struck down. That analysis is, in my opinion, a little bit beyond what we need to get into here today, okay? But just know that, when applying this opinion to future opinions, the court is supposed to take, a pretty hard look at the laws, and it could sort of go 50-50. So they're not supposed to strike down anything that comes in violation of the Second Amendment, or just let anything go. Their standard of review would be right in the middle, intermediate, okay? So the second part of the law, the requirement that guns be unloaded and trigger protected, Scalia turned to this requirement that any gun which is not completely forbidden be kept unloaded and inoperable in the home. This requirement, he said, makes it impossible for its citizens to use such guns for their core lawful purpose of self-defense, and is hence unconstitutional and violative of the Second Amendment. So basically, first, he's saying you can have handguns in the home. Second, he's saying you can have them loaded and assembled. That's what that D.C. law did, said no handguns, and even guns that you were allowed, you can't have them loaded and assembled. He said no. Rejects an interest balancing approach. So, the dissent here, and maybe we'll get into the dissent in a later episode, wanted to weigh the interests of the law, which is like protecting people, with the right, which is allowing people to have guns in their home. Scalia rejected that, okay? He said, that's not how we're going to do it here. He's basically said, the handguns in the interpretation for the Second Amendment is going to be an intermediate-based inquiry of scrutiny, but it's not an interest-based. So that gives a tremendous amount of power, okay, to this case as it's analyzed in the future, saying that the right in and of itself outweighs any interest. That's kind of what he is saying here. Scalia then wrapped things up by saying that so long as the plaintiff was not disqualified from the exercise of Second Amendment rights, such as becoming a felon, etc., the District of Columbia must permit him to register his handgun and must issue him a license to carry it in the home. Handgun violence. Scalia conceded that handgun violence was a serious problem in America, and that some measures regulating handguns would be constitutionally acceptable methods of dealing with the violence problem. But, he said, the enshrinement of constitutional rights necessarily takes certain policy choices off the table, which is what I was just saying before. These include the absolute prohibition of handguns held and used for self-defense in the home. Now, a later decision came down from the court which said that, so D.C. is basically federal law. They passed federal law because it's a federally governed district in the United States. And a law that came out in 2010, McDonald versus the city of Chicago, then applied this decision that Scalia made to all the states. Okay, so this is now nationwide constitutional law. Now, let's talk about the effect on gun laws by this decision. And this is sort of what, what we know practically going forward after this law. Even though we know from McDonald, Second Amendment applies to state and local gun laws, it's not clear that governments will lose very much of their practical power to regulate gun use. This is very relevant to everything that's happening in Virginia right now. Heller and McDonald together pretty clearly mean that a total ban on handgun possession in the home would be unconstitutional, as would a requirement that non-handguns be stored in an interoperable and unloaded manner. So, for instance, Chicago's virtually complete ban on handguns, which was at issue in the McDonald case, but which the Supreme Court remanded to the lower courts, is vulnerable. But few cities, and no states regulate handguns nearly as extensively as DC and Chicago do, so their restrictions may very well survive. It seems likely that licensing requirements will not be found to violate the Second Amendment as long as the procedures for licensing are not unreasonably burdensome and are directed towards keeping guns out of the hands of people who do not have Second Amendment rights to possess them. So, for instance, since Heller makes it clear that a government may ban felons and mentally ill from possessing guns, a licensing requirement that would deny permits to such people and that would give government a reasonable amount of time to check whether the applicant fell into these categories would presumably be valid, even if some form of strict scrutiny were used. So again, that gets into the type of review, but the important thing is that this decision seems to protect licensing schemes on the part of government for weapons. Concealed carry permits. Similarly, it seems likely the amendment will be found not to prohibit governments from banning the carrying of concealed weapons in public places. That's interesting. The majority opinion in Heller commented seemingly approvingly that the majority of 19th century courts to consider the question held that prohibitions on carrying concealed weapons were lawful under the Second Amendment or state analogs. Furthermore, if, as the Heller majority asserts, the thrust of the Second Amendment is to protect citizens' right of self-defense at home, it's hard to see how the amendment is violated by prohibiting the carrying of concealed weapons outside the home, barring certain types of weapons. One last open question is the types of weapons the possession of which is guaranteed under the Second Amendment. Scalia's opinion seems to agree with the 1939 Miller opinion in holding that only those weapons which were common in use at the time the amendment was adopted are protected. Very originalist there. And that, in the words of an 18th century commentator, dangerous and unusual weapons may be prohibited. Well, I mean, I don't think most of us think that we should be allowed to have tanks, though I know some of you out there do. I've seen some pretty hilarious memes of tanks in driveways. So presumably governments may ban the possession of modern weapons that are much more advanced and dangerous than those existing in 1791, such as machine guns, assault rifles, sawed-off shotgun. The sawed-off shotgun was at issue in Miller. So although the Second Amendment now recognizes some sort of individual right to bear arms, that right is likely to be found to be subject to heavy governmental regulation. And at the end of the day, it may well be the case that of gun regulations actually adopted by states or cities, only the very most extreme measures, like the one in DC, which banned handguns completely and required trigger locking of guns stored at home, would be struck down. So in sum here, this case was fascinating because it created it was the first case that said, you can have a handgun in your home, you can keep it loaded, okay? And the Second Amendment protects that. Again, I can't believe that wasn't done until 2008. However, this decision left open a lot of room for the government to regulate weapons. So look hard at what's going on in Virginia. Perhaps you can do some constitutional analysis. Give me a comment below. Let me know if you think the laws in Virginia are going to be upheld or struck down constitutionally. I'm going to do my own analysis. We're going to come back and look at about 4 or 5 parts of those Virginia laws and see if they would hold up under Heller. The interesting thing that I found about Heller is and you try to read the tea leaves, and right now we have a pretty conservative court. It's 5-4. Justice Gorsuch and Kavanaugh are both pretty conservative. Kennedy's no longer on the bench. You've got Alito, you've got Thomas, and you've got Roberts, who's perhaps the most liberal of the 5 conservative justices, but I think he's pretty conservative when it comes to gun rights. I could see if, and I don't know if the laws are going to do this, concealed carry permits are almost certainly going to be, okay. But I could see an area of law in the future being if states or local governments tried to ban the carrying of weapons in public outright, I could see the new justices, the new makeup of the Supreme Court, interpreting perhaps an individual right to self-defense and to carry handguns outside of the home. I think that's a possible frontier for new constitutional law, because what Scalia is saying is there's an inherent right of self-defense in the Second Amendment. Well, here's the thing. If that right exists in the home, why wouldn't it exist outside of the home as well? Now, the Heller opinion doesn't go that far, but I think if there's some regulation that happens which tries to take away public carry or even concealed carry and open carry might be reasonable, but concealed public carry with a license, okay, if some states try to infringe on that right, I could see a challenge it going up to the court, and Heller opinion actually being expanded with the current makeup of the court. Now, I don't believe that what I just quoted there is going to be what's at issue in the Virginia laws that are being passed. But keep in mind what I said. Maybe not 5 years, maybe not 10 years from now, but I think that's a possible frontier for the expansion of Second Amendment rights, is the right to carry a firearm, a handgun, outside of the home. I hope that you found this interesting. Please, let's continue the discussion. Leave comments for me and I will discuss this with you. I'm going to do future videos on the Second Amendment if I get a lot of positive feedback here. Thank you for tuning in. I'm Joe Pometto, Joe the lawyer, a practicing attorney in Pittsburgh, PA. I also served in the Air Force for 4 years. I know how to use a weapon. I'm not the most skilled or knowledgeable, but I do support the Second Amendment. But I can see the case for reasonable regulations. Regardless, we're going to talk about Virginia next. Please like, subscribe, comment, and share. Especially subscribe to my channel. I'm trying to get to 1,000. I need those subscribers. Hit the notification bell. Watch my videos. Thank you for tuning in.